I think, Your Honor, I'd like to call Gabriel Adams if the court's ready for that. It's going to be a little bit of a longer one.
Yep.
There's two cases.
Yep.
The first is 5A ending in 846, and the next is 5A ending in 243.
Okay.
On the pending assault for the ED case, this is going to be a plea to the amended charge of disorderly conduct. And it's going to be a motion and proposed order for a stay of proceedings on the no contact order violation charges.
Okay. Okay. Disorderly conduct is our plea. The protection order charges are all on the same stay, it looks like. Okay, Mr. Adams, if I could have you state your name and date of birth, please, for the record.
Gabriel Adams, April 4th, 1987.
The plea form here shows you are 38 years old and you've completed a bachelor's degree. Is that correct?
That's correct, Your Honor.
Are you able to read and understand the English language?
Yes, sir.
In entering a plea today to an amended charge of disorderly conduct, you are giving up some rights that are associated with the original charge of assault in the 4th degree domestic violence. I am going to review those rights with you. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. Do you understand those rights, Mr. Adams?
I do, Your Honor.
Understand that in pleading guilty today, you're waiving or giving up those rights.
I do, Your Honor.
Okay. The charge that you are pleading to is what is called a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. There is a pretrial agreement, sir. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
I understand, Your Honor.
And I have the PTA for the stay case. Let me look. Maybe I have it down here. I don't see the PTA for the disorderly conduct. It's in the notes on the same one. Okay, I do see that. I apologize. Okay, I see that. So do you understand, sir, the court does not have to follow anyone's recommendation as a sentence, but can sentence you up to the maximum authorized by law?
I understand, Your Honor.
Okay. Court can place you on probation on this case for 2 years, during which time you'd pay cost, fees, and assessments as authorized by law. And this is being amended to a non-DV charge? Okay, just wanted to make sure. Okay. To the charge of disorderly conduct, sir, taking place May 17th, 2025 in the city of Richfield, Washington. How do you plead?
I plead guilty, sir.
I understand it's a Newton plea. I'm just trying to, there's no location or date
Okay. Oh,
on the plea.
sorry about that, Your Honor.
That's okay. I'm gonna just initial that I've written that part on.
Thank you.
Okay. Are you making the plea today, sir, freely and voluntarily?
I am, Your Honor.
Has anyone made any threats or promises to get you to plead guilty?
No, Your Honor.
Okay. So the factual basis reads Newton plea. I believe that if the prosecution set forth the facts contained in the police report, there is a risk the jury could find me guilty of the underlying charge. So that charge is disorderly conduct. As a consequence, I wish to take advantage of the prosecution's offer and plead guilty to the amended charge of disorderly conduct. Is that correct?
That is correct, Your Honor.
And the facts I've added in was that charge took place on May 17th, 2025, and the location of the charge was in Richfield, Washington. Is that correct?
That is correct, Your Honor.
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Now, my thought would be that we have a right to allocution on the plea. My thought is I'm going to probably do the stay now, if that's in agreement with everybody. And then I'll hear from all the parties at the conclusion of that. It's all right.
Sounds great, Your Honor.
Okay. So this is 6. Okay. So Mr. Adams, you've been sitting in court. You've heard me place a few other folks in the on stays. The first thing I will tell you is the same thing I told them. The court is not a party to the stay. This is a contract between yourself and the city of Richfield. My duty is to ensure that you understand the terms of the agreement, and that if you follow the agreement, in this case, the 7 charges would be dismissed. There are some financial obligations in the form of a $150 filing fee, a $150 supervision fee, and a $300 public defender recoupment, which is a total of $600 that is going to be paid on a payment plan over during the 12 months of the stay. You are going to complete 3 days on the work crew program. You must do at least 1 day of work crew every 30 days. If 30 days pass and you have not done work crew, it does get returned to me. When you finish the proceeding today, I want you to go to the same location you checked in for court and ask to speak to the work crew chief. You are to... So the part about, okay, so if you have not already, you are to complete a domestic violence evaluation. You are to comply with any treatment recommendations, and provide certainly a copy of the police report prior to that evaluation. You're to have no contact with Sierra Adams, and I do see there's a formal no contact order here that I'm likely going to be signing. You are not to have any new charges. You're to appear at all future court dates. In entering the stay of proceedings on these 7 charges, you are giving up the right to jury trial on all 7 counts. You understand that right, sir?
I do, Your Honor.
And are you in agreement with waiving or giving up that right?
I am in agreement.
You're also doing a waiver of speedy trial on all 7 counts. The commencement date, I think, is probably, Mr. Wallace, from when we expected to do this a few weeks ago. Do you mind if I change that to October 2nd, 2026?
Not at all. Thank you.
Okay. Mr. Adams, do you understand your right to speedy trial, sir?
I understand, Your Honor.
And do you understand that in commencing or beginning that speedy trial right a year from today, you are giving the city of Richfield on all 7 counts 90 days from that date if it became necessary to bring you to trial? Are you in agreement with that?
I'm in agreement.
I'm going to find that you're making a knowing, intelligent, and voluntary waiver. All charges that you're entering are all gross misdemeanors. Ms. Carmi, I see that you didn't sign the stay of proceedings here.
It should be.
Both pages, it looks like. Thank you very much. All right. So we're going to set a review date, Mr. Adams, to check in on the conditions. That's going to be on Wednesday, the 31st of December, 2025. At that time, I'll be looking at your progress with the work crew, the domestic violence evaluation, and any recommended treatment. We're going to set a final review date to the nearest court date a year from now. That'll be October 1st, 2026 at 1:30. That will be a mandatory court date, sir, and if you are in compliance at that time, the charges will be dismissed. Do you have any questions of Mr. Wallace or of the court before I sign you into the stay of proceedings?
What time would the court hearing be on the 31st of December?
That's at 1:30 in the afternoon, sir.
Okay, that should be fine.
Any other questions?
No, Your Honor.
That concludes the stay of proceedings. Okay. So. At this point, we need to proceed with sentencing. At this time, we're going to do a couple of things, sir. I'm going to hear from your attorney, Mr. Wallace. I'm going to hear from the city attorney, Ms. Carney. You will also have the right to speak, and I understand that Ms. Adams also wants to address the court. So that's the order that we're going to go in. Mr. Wallace, Ms. Carney, yourself, and then Sierra Adams, okay? Go ahead, Mr. Wallace.
Thank you very much, Your Honor. This has been a case that has been in negotiation for some time. My client has been in constant communication with me and been very easy to work with throughout this process. He's been arrested twice, once on the initial allegation of assault, once on the allegations of no contact order violation, and served, I believe, 5 days in custody. And so those days are contemplated in that agreement that's been handed forward to the court. We're asking that you follow it. We're hopeful that you follow it. So of the 10 days work crew contemplated on that offer, parties contemplate 5 have been served, which would leave 5 additional to serve. This case has been a challenging one. There are some significant weaknesses from a defense perspective in this assault case, which I think is why it's resolving the way it is. There was a video of the alleged incident. And, from the prosecution's perspective, I think that there would have been some significant challenges proving both intentionality of contact and whether the contact was offensive, because it certainly wasn't harmful. So it was with the no contact order violation charges that came that really complicated things from a defense perspective. Otherwise, I think this is a case probably that may have moved towards a trial posture. Having said that, we're very grateful to Ms. Carmen for the offer and for negotiations in this matter. I know my client is very grateful for the opportunity to have the no contact order violations dismissed. He's ready to move forward. He wants to start the next chapter in his life and support his daughter. The parties are in the midst of a divorce. There's a civil protection order case as well. So there's a lot that they're all dealing with, and it's a hard time of life for everybody. From a financial perspective, my client works at Trader Joe's. He earns approximately $2,800, $2,800 to $2,900 per month. He supports himself, still supports his spouse and their child. So he supports 3 people if you can include himself. So to the extent the court can waive fines and fees, we'd ask it to do so. My client's also seen a psychiatrist and counselor. He's been doing that, and he's hopeful he'll be able to use evaluations through those folks to fulfill his evaluation requirements pursuant to the offer if the court decides to follow it. And unless the court has any questions for me, I think that's all I have.
Ms. Carney?
Yes, Your Honor. Being in the prosecution role, we very clearly aren't advocates for a victim or a defendant or the city, frankly. We're kind of here to figure out what is justice in the circumstance and what probably keeps the victim and the community safe long-term. So our overarching goal with a first-time offense like this is the treatment. And so, compliance with the assessments and treatment is our #1 goal with regard to this case, and that is being requested. The no contact order is at the request of the victim. We understand there is a civil protection order. These parties are involved in a dissolution. Very emotional and difficult time for all parties. So we are requesting that the no contact order post-conviction remain in place. I believe Mr. Wallace added language, which we agree with, that should the CPO be amended, whatever is allowed under the civil protection order shall be allowed under this order. I do understand that the victim may wish that the convictions were harsher to some extent, and I understand that perspective. But as Mr. Wallace said, as the prosecutor, I do have to look at the strength of a case, the type of conduct that occurred, how a jury may likely view a case, and that is why I have put forth the recommendation that I have.
Mr. Adams, go ahead.
I would just like to say I take all this very seriously. As Mr. Wallace mentioned, I am in both therapy and seeing a psychiatrist and following all their recommendations. So my goal is just to focus on being a better person and to continue providing for my family.
Ms. Adams, if you're ready, unmute and go ahead.
Your Honor, thank you for allowing me to speak today. I've prepared a written statement that I'd like to read if that's okay.
Sure.
Okay, thank you. So I am the victim in this case, and I want to share how the proposed plea deal affects me. The incident that led to this charge was fully captured on video. It was clearly an assault, and because of that, I respectfully ask that the charge reflect what actually happened. I want to be clear, I'm not asking the court to put him in jail. My child and I rely on him financially until I secure employment. And I understand that probation, treatment, and work crew are appropriate. But I do ask that the assault for DV charge remains, since that is the crime that was committed. To me, keeping the original charge better acknowledges the seriousness of the assault and the courage it took for me to come forward. This was not an isolated event. There is substantiated evidence showing repeated physical assaults from Mr. Adams throughout our marriage, including while I was pregnant and postpartum. Because of that history, Commissioner Lako of the Clark County Superior Court reviewed a large amount of evidence and granted a domestic violence protection order that includes both my child and me as the protected parties. Commissioner Lako also ordered that Mr. Adams have only professional supervised visitation with our child after reviewing the evidence. In addition, there have been multiple protection order violations leading to his second arrest, which were documented through Mr. Adams' own text messages. Ms. Carmi and the Ridgefield Police Department have the video evidence of the assault and the screenshots of the protection order violations. For these reasons, I believe it's appropriate that the assault for DV and protection order violations remain as the charges rather than being reduced. Mr. Adams committed these crimes, and the evidence substantiating them is fully documented. Respectfully, I believe it's imperative that he be held accountable with charges that accurately reflect the seriousness of his actions, especially given the prolonged history of abuse spanning many years and his demonstrated lack of remorse. I also fear that reducing his charges would only empower him further, and this genuinely places me in fear for both my safety and my child's safety. And finally, I want to share that I am fearful even speaking here today because Mr. Adams is in attendance and can hear everything I say, and I worry about retaliation simply for telling the truth, and that fear is very real for me. Thank you, Your Honor, thank you, Your Honor, for your time and for hearing me.
Thank you. So this is whenever we're addressing domestic violence cases in particular, the first thing I tell folks, even at arraignment, and putting this robe on, it does not give me any kind of insight into a person's life, what they've gone through, the road they've walked down, those sorts of things. There's no superpowers that are emboldened in wearing this. I am just a person like everybody else. To that end, the court has to take a very small slice of what happened. And sometimes the court can extrapolate from that. Other times the court cannot. One of the things that the court is limited to that a civil court is not limited to is that a civil court can explore things that are not before the court, meaning previous allegations, those sort of things can be heard by a civil judge. The civil judge can consider those sort of evidence. A criminal judge is limited. Criminal judge is limited by the slice of information that that judge has provided. Criminal court is also limited by the charges that are brought in front of the court and the charges that are amended. I would say that Ms. Carmy has aggressively pursued this case. I know that in terms of the 7 counts that were brought, that this court probably had a few questions about a few of the statements and whether they rose to the level of violating the protection order. That said, any of the statements that could have been construed as protection order violations were brought by the city. And those charges remain stayed at this point. And very simply, what that means is it is in the power of Mr. Adams to have all 7 of those charges come back if he were to commit new criminal offenses, if he were not to follow the terms of the stay. So I think that the way that the court would settle as of today is that it's really in his hands how successful or not successful this stay of proceedings is. Very simply. I think that that is what justice is if we want to not just incarcerate a person, throw away the key, and say you're never going to have a second chance, right? You two are eventually going to have to become co-parents. You have a daughter. He is her father. You are the mother. You're going to have some role where eventually you're going to have to coexist. That's probably in the best interest of everyone, but this is not what this court is here for. It's not my role to say who does what and what conditions are and that sort of thing. But if truly the bridge is ever to be rebuilt, it's to be rebuilt doing the things that the stay is supporting. Not violating the law, getting domestic violence evaluation, complying with treatment, taking those necessary steps. This is a person that does not have a substantial criminal history. And I think generally both the court and the defense and the state in these circumstances try to give the benefit of the doubt. And again, the court can't consider things that happened in the past that may have been uncharged and within the contemplation of the civil court. Okay? So I am going to follow the recommendation of the parties. I have entered Mr. Adams onto the stay. I am going to follow the recommendation. He has already served 5 days of jail on the disorderly conduct. So as to count 1, it'll be 90 days of jail with 80 days suspended with 5 days to serve in custody. Credit for those 5 days. The balance of 5 days, Mr. Adams, will be done on the work crew. We've already talked about talking to the work crew chief today. I understand that you're supporting a number of people, and I understand the court does not want to have any collateral financial consequences that flows to the victim or flows to your daughter or anyone else. So the court is going to find you indigent under a Blazina analysis, meaning I'm not going to impose any fines, fees, or cost. It'll be $1,000 with all $1,000 suspended. We want you to put your resources towards your wife, or soon-to-be ex-wife, your daughter, and certainly towards that necessary therapeutic response. Your conditions of sentence are no law violations. Court's going to be very stringent on this. Sometimes I have someone come back and it's a traffic offense. I think this is a zero wiggle room type situation. When there's this many counts on there, perfection is going to be the standard. Okay. Bench probation for 24 months. Again, This is speaking towards this case, but certainly on the stay is what I was referring to. The conditions on this case are concurrent or running at the same time as the obligations on the stay. There is, it looks like, some provisions under the civil order that's in place. There is a provision here that it looks like will try to make this no contact order a living document that's going to modify as the civil waves ebb and flow. Okay. So it might be that there's terms in this agreement that are eventually changed by the civil order. When there's multiple orders, as I've talked to you two before, these become more complicated, and you're going to always have to defer to the higher order. And at least at this point, in terms of our document, that higher order is going to be the Clark County Superior Court order. Okay. There is, I guess, an outside possibility that at some point there's enough modifications that this becomes the more stringent order. And we can account for that if that does take place sometime in the future. As you've heard me tell everyone where a no contact order is entered, you are held to a very high standard of understanding 6 pages of a complex legal document. There is no, I didn't understand, I didn't get it, those sort of things, right? This is something where you're held to the standard of an attorney, and you're going to have to navigate that. If you have any kind of belief that your conduct might be violating the order, do not take action until you talk to an attorney if you have one on your civil case or something else. We are going to set a mandatory return date on this case for the same date as the other case, which was the 31st of December, 2025. Now, my question, Madam Clerk, is that a full court day for us? Morning docket only. So I said 1:30 initially, and now I'm going to say 10 a.m. Does that still work for you?
That's actually better. Thank you.
Okay, so it'll be 10 o'clock in the morning that day. Will be that docket. We're going to get you some paperwork over at the desk by the door. Again, I have encouraged you to check in with the work crew chief before you leave today. I have signed off on the no contact order. I think that concludes all of the matters before the court. I thank the parties. I know this was something that was ready to go a couple weeks ago. I thank the parties for their patience and the ability to come back a second time. So thank you all.
Thank you, Your Honor.
Thank you, Your Honor.